High-profile names are once again dominating global headlines, as newly unsealed court filings connected to Jeffrey Epstein bring renewed scrutiny to a scandal that many believed had already revealed its darkest secrets. Years after Epstein's 2019 arrest and death in federal custody, the legal aftershocks of his case continue to ripple across political institutions, corporate boardrooms, royal households, and elite social circles. But this time, the attention is not centered solely on the crimes themselves. Instead, it focuses on the identities appearing within court documents that were once sealed from public view. The latest document release, overseen by the United States District Court for the Southern District of New York, has reopened public debate about transparency, accountability, and the powerful individuals whose names surface within deposition transcripts, contact lists, flight manifests, and witness testimony. The release does not represent new criminal charges. It does not automatically imply guilt. But it does reveal how deeply embedded Epstein was within elite networks that spanned continents. To understand why this matters, we must revisit how this story evolved. When Epstein was arrested in July 2019 on federal sex trafficking charges, prosecutors alleged that he operated a scheme involving the sexual exploitation of underage girls. His private residences in Manhattan, Palm Beach, and his private island became central to the investigation. Yet before the federal case could proceed to trial, Epstein was found dead in his jail cell, a death officially ruled a suicide. That single event triggered a wave of public suspicion and conspiracy theories that continue to circulate today. But the legal battle did not end with his death. Attention quickly shifted to his longtime associate, Ghislaine Maxwell, who was later arrested, tried, and convicted for her role in recruiting and grooming underage girls for Epstein. Her conviction reinforced the legitimacy of the victim's claims and confirmed that the network was not a fiction, but a criminal enterprise with documented victims and corroborated evidence. Still, one question persisted. Who else knew? That question has fueled years of civil litigation, investigative journalism, and public demand for transparency. Among the most significant legal efforts was a defamation lawsuit connected to Epstein accuser Virginia Giuffre. It is through related civil proceedings that many of the now unsealed documents originally surfaced. Depositions taken years ago, once heavily redacted, are now available in more complete form. And that is where the current storm began. The newly released filings include hundreds of pages of witness statements and legal arguments. Within those pages are references to politicians, billionaires, academics, and celebrities. Some names appear only in passing. Others are mentioned in more detailed contexts. Importantly, legal experts emphasize that being named in a document does not equate to criminal wrongdoing. In legal proceedings, names can surface for many reasons: social acquaintance, travel association, financial transaction, or simple mention in testimony. However, in the court of public opinion, nuance often disappears. The media cycle accelerates, social media amplifies fragments of information, headlines grow sharper, context becomes compressed into viral posts. Within hours of the document release, global news outlets began analyzing every line. Television panels debated implications. Online communities dissected flight logs and contact entries. One of the most discussed components involves Epstein's private jet travel records. For years, these logs have been referenced in investigative reporting. The new filings add additional context, including deposition excerpts discussing who traveled where, when, and under what circumstances. Yet again, experts caution that travel does not equal knowledge of criminal behavior. Association does not equal participation. Still, the scale of Epstein's network remains staggering. Some individuals named in the filings have already issued public statements reiterating prior denials. Others have acknowledged social contact but denied any awareness of criminal conduct. In a legal sense, no new charges have been filed against those individuals as a result of these unsealed records. The documents themselves are part of civil litigation history, not fresh indictments. Yet the reputational consequences can be immediate. For public figures, even peripheral mention in a case of this magnitude carries weight. Corporate boards evaluate risk. Political opponents seize opportunity. Advocacy groups demand investigations. The distinction between legal liability and public perception becomes increasingly blurred. This unfolding moment represents more than a scandal revival. It highlights a broader cultural tension between transparency and presumption of innocence. Courts operate under evidentiary standards, media operates under deadlines, social platforms operate under virality, and the public stands at the intersection. Why were these documents sealed in the first place? Court records are often redacted to protect victim identities, safeguard ongoing investigations, or preserve privacy during litigation. Over time, as cases conclude and appeals resolve, judges may grant motions to unseal materials if deemed in the public interest. In this instance, advocacy for transparency played a major role in bringing the documents into daylight. Transparency, however, brings complexity. The filings are dense. They contain legal language, cross-examination fragments, and contested assertions. Without legal training, it is easy to misinterpret context. A single line quoted without surrounding testimony can dramatically shift meaning. That is why legal analysts urge caution. The Epstein case has already demonstrated how narratives evolve over time. Initial reporting in the early 2000s did not fully capture the scale of abuse. Subsequent investigative journalism expanded understanding. Federal prosecution confirmed criminal conduct. Civil lawsuits revealed additional layers. Now the unsealed filings add yet another dimension. The story is not static, it is cumulative. As Part 1 concludes, one reality becomes clear. The resurfacing of high-profile names is not merely about who appears in a document. It is about the enduring shadow of a scandal that exposed vulnerabilities in systems of power. It is about how wealth, influence, and social access intersect with accountability. And perhaps most importantly, it is about whether transparency can truly lead to closure. This is only the beginning. The newly unsealed filings reinforce just how expansive that network was. Flight logs referenced in depositions show patterns of travel between New York, Palm Beach, New Mexico, and Epstein's private Caribbean island. Contact books reveal phone numbers and email addresses of individuals spanning multiple industries. Testimonies describe meetings, conversations, and social visits. Yet again, legal experts emphasize, documentation of association does not automatically establish knowledge of wrongdoing. Still, the scale itself raises questions. How did Epstein maintain social credibility even after his 2008 plea agreement in Florida? Why did elite institutions continue to interact with him? And how did the warning signs fail to trigger broader institutional distancing? To answer these questions, analysts examine the mechanics of elite networking. In high-level social circles, reputation often operates through endorsement. If one respected figure vouches for someone, others may follow. Over time, presence becomes normalization. A controversial figure at one event becomes a familiar face at the next. Gradually, scrutiny fades. The filings suggest that Epstein benefited from precisely this dynamic. Some deposition excerpts discuss introductions facilitated by mutual acquaintances. Others reference philanthropic donations or intellectual collaborations. Epstein was known to present himself as a patron of science and education, engaging with researchers and institutions. These connections created layers of legitimacy. When reviewing the documents, it becomes clear that influence does not require formal titles, it requires positioning. The case also reignites scrutiny around institutional oversight. Universities, charities, financial firms, and political campaigns all operate within compliance frameworks. Background checks, donor screening, and ethical reviews are standard procedures. Yet history shows that wealth can complicate those safeguards. When large sums of money enter philanthropic pipelines, decision-making may shift toward opportunity rather than risk. The renewed attention has led advocacy groups to call for stronger transparency policies within elite institutions. Some universities have publicly acknowledged prior donations linked to Epstein and have implemented reforms. Corporate entities have reevaluated governance standards. The broader cultural lesson is still unfolding. Meanwhile, the role of the judiciary remains central. The unsealing of these documents occurred through proceedings in the United States District Court for the Southern District of New York. Judges face competing arguments: protect privacy and prevent misinterpretation, or prioritize public access in a case of significant national interest. Ultimately, transparency prevailed, but not without careful review and redaction to protect victim identities. Size. This legal balancing act highlights a core tension in democratic systems: openness versus fairness. Within the filings, certain names appear multiple times. Others appear only once. Context varies widely. Some references involve scheduling meetings. Others involve testimony about social gatherings. Each mention carries a different weight, yet public discourse often treats them uniformly. Legal analysts stress that deposition testimony reflects what a witness states under oath at a particular time. It may include allegations, recollections, or assumptions. Those statements are subject to cross-examination and legal challenge. They are pieces of a broader evidentiary puzzle, not final verdicts. Nevertheless, reputational impact does not wait for judicial clarification. Political figures whose names surface may face renewed media scrutiny. Opponents may demand explanations. Corporate leaders may encounter shareholder pressure. Public trust, once shaken, can be difficult to restore. And yet, amid this intense focus on the powerful, survivors' advocates remind the public of the central issue: justice for victims. Determined. The criminal case against Ghislaine Maxwell affirmed that exploitation occurred. The testimony of accusers, including Virginia Giuffre, played a significant role in exposing the system that operated around Epstein. For many survivors, the unsealing of documents is not about celebrity exposure, it is about acknowledgement. Emotional acknowledgement that their voices were once dismissed, acknowledgement that power did not shield everyone forever, acknowledgement that secrecy eventually gives way to record. As Part 2 unfolds, a broader realization emerges. The Epstein saga represents a case study in how influence operates behind closed doors. It reveals how wealth can facilitate proximity, how proximity can generate trust, and how trust, when misplaced, can enable silence. The documents themselves are static, ink on paper, transcripts of words spoken years ago, but their impact is dynamic. They shape conversations about accountability. They prompt institutions to reassess their policies. They challenge the public to differentiate between allegation and adjudication. The question now is not simply who is named. The question is, what systems allowed those names to converge around a man later exposed as a criminal? And as the narrative continues to unfold, one thing becomes certain. This is not just a story about past misconduct. It is a reflection on how modern power networks function, and how fragile the boundary between influence and immunity can become.